All right, here we are for another, let's just say, roundtable with two people. And it's the educational seminars that I'm putting on my YouTube channel. Today I have a special guest and a friend. We've gotten to know each other, I don't know, what's it been, 3-4 years now?
Oh, it's been longer than that.
Has
I think
it?
7.
Oh God, you know, so COVID screwed everything up, right? Because I don't even think I saw you for like a year and a half.
Probably.
Yeah. So Jodi Bohr.
Bohr.
Bohr. I should know your last name. So Jodi Bohr. I didn't want to call you Bohr for some reason.
Oh.
No. Anyways, this is not going to be a bore, I promise you. So she's with Tiffany Bosco Law Firm.
Yep.
And you're in Phoenix, right?
Yes.
Okay. And tell the viewing audience exactly what you like, kind of a little bit of your background and what you specify in.
Sure. So I've been practicing law for about 19 years now, exclusively or almost exclusively in employment law, meaning I represent companies who need any sort of assistance in navigating all of the employment laws that are out there, either FMLA, ADA. I could go through the entire alphabet of employment laws, but that's what I help them out with. And if I can't prevent, or if they don't come to me soon enough to prevent a lawsuit, I represent the companies in the lawsuit as well.
And you've been doing this for how long?
19 years.
19 years.
Yes.
Wow. And I'm sure you've seen a lot of stuff over the 19 years.
Oh, you bet.
Yeah, a lot of fun stuff. So specifically, what I want to talk about is obviously I'm a hospitality specialist in insurance, and so I want to talk about, you know, just HR and hospitality and what that means, and kind of get your thoughts on what is the definition to you of hospitality? What does that mean to you?
Sure. So in my business, I could do, I can represent hotels, so I kind of add them into my hospitality definition, or restaurants, and sometimes retail a little bit, but mostly just kind of hotels and restaurants.
Hotels and restaurants. And would you say that that sort of clientele for you, the hotels and restaurants, maybe has a different type of identity compared to your normal office situation?
Sure, absolutely. There's a lot of unique situations that arise from hospitality clients.
Yeah, and what are some of the biggest? I mean, if you had to guess, just based on representing and stuff like that, is it usually, you know, the tips portion of it, the time off, the sexual harassment? What do you see like most of, or is it all the above?
It's really all of the above. You hit it all, the nail on the head. So you see a lot more harassment sort of claims in hospitality. Tips are a hotbed issue, especially with the fluctuation in the law over the years. And then paid sick time I've seen come up as an issue because, to be honest with you, servers and hostesses, they'll call their supervisor to call in sick. The supervisor fails to notify the payroll manager and then paid sick time isn't paid.
Yeah.
So.
And how, when you're looking at tips and wages and all that, how misunderstood is that line item by most business owners?
Oh, it's really misunderstood. A lot of them don't understand that you can't include the back of the house if you are taking the tip credit, but you can include the back of the house if you're not taking the tip credit. That's relatively new, and so there's just a lot of different unique aspects of the tip credit and all the certain things you have to follow.
And all of these laws tend to change how often?
Oh. You know, some of it changes with the administration.
Really?
So, for example, the Trump passed the tax appropriation bill, and embedded in, I think it was an 800-page statute, was the Tips Protection Act. And so a lot of it is administration-based because they can do a lot of changes through agencies as opposed to just statutes as well.
Right, okay.
Yeah.
And for the terms of what we're talking about here, we're primarily focused on Arizona, so if you're watching in a different state, kind of take all this with a grain of salt because we have Arizona minds working here.
Correct, yes.
Okay, how about what's the value you would put on, not just because you do them and you help companies with this, but what's the value you would put on an employee handbook?
I think they're very important. And I have clients who have 1 or 2 employees that have had me prepare handbooks. And the reason they're important is because they manage expectations for employees. One simple example is if you put in your handbook that you do not pay out paid sick time or vacation on termination, then it's no longer a question because you're not required to under Arizona law. It's really what you put in your policy that manages the employee's expectations. And that's the same for a lot of Arizona policies. Arizona law does not dictate a lot of different things, and so really it's dictated by what you say in your handbook.
Interesting, very interesting. So you're talking 2 people should have an employee handbook to 500 people. And
yes.
Yeah, I mean, because everything is dictated the way, it's almost like the Bible of your company in essence.
Yeah, and it can be really industry specific.
Yeah.
Of course, with hospitality, you're going to have a tip pooling policy. And again, that needs to be disclosed to employees up front.
Yeah.
So that's really important to have in a handbook. But other industries clearly wouldn't have something like that.
Is it beneficial, hopefully I'm asking a rhetorical question here, is it beneficial to have, upon a new hire, to have sign-offs on certain things, like I understand these aspects of the culture and, I'm not going to sexually harass somebody or,
Absolutely. And I use that as evidence in anytime I respond to a charge of discrimination with the EEOC, and that's the Equal Employment Opportunity Commission, I tell the EEOC, look, we have a handbook, here are all of our policies, and here is a piece of paper that shows that this specific employee received the handbook and knows about our policies.
Yeah, and so there could possibly be some protection on the establishment's behalf because they've put these protocols in place.
Yes, some statutes have safe harbor provisions
Yeah.
that say if you have this policy in place, there's a little bit of added protection that you have.
Yeah, I mean, and in insurance as well. I mean, when I look at it, when you're completely negligent, okay, and just ignoring the problem and letting it pursue, that's a little bit different than if you really just don't know about it and all of a sudden it kind of came and hit you.
Correct.
Yeah.
Yeah.
Okay. What are there some besides an employee handbook? Are there some quote unquote like what's your idea or what are some of your top best practices for a hospitality establishment to protect themselves?
Sure. I think one of the things is to make sure that you are updated or you've updated your postings. Okay. There are, I don't even know how many, there's probably 10 to 15 posting requirements if you combine state and federal posting requirements that need to be in some form of break room or area that everybody has access to. I think that's incredibly important because, for example, under the Arizona Minimum Wage Act, you need to update that poster every year, regardless of whether minimum wage changes.
Wow, I didn't know that.
And if you don't have that posting up, you could get penalized if somebody files a claim with the Industrial Commission of Arizona.
Interesting. Hey, Kristen, is our posting? Wow. Okay. This is all great information. So that's one of the best practices, obviously posting stuff like that. We talked about the handbook. We talked about the sign-offs. How important, based on what you see, is creating a culture of equality, a culture of people being able to come talk to, management or owners or stuff like that, not being ignored?
Yeah, I think it's incredibly important. You need to have employees who feel comfortable to come to you with any sort of issues. If they don't feel comfortable coming to you with those issues, they're going to be going to government agencies to make those complaints.
Yeah, for sure. And by the time it gets to a government agency, is it pretty much too late?
It can be, in a way, because you really need to be getting counsel involved at that point. And so it's too late in the sense that now you're paying attorney's fees to resolve an issue that really you probably could have resolved without the government intervention and the time that it takes to resolve the complaint with the government.
So to rephrase what you just said and kind of answering that question is that you should really find somebody like Jodi who can help you in the beginning to kind of put all this together to avoid litigation later on. So it's like pay now or possibly pay even more later.
Pay way more later.
Way more later.
And I'm glad you brought that up because I always say when somebody says, when should you hire an employment attorney? I say early and often.
Yeah.
Early, get your handbook done to manage expectations. And often, if you have a question, just call, get the answer to the question taken care of, and then hopefully do the right thing to avoid potential liability down the road.
Yeah, and so, without obviously, you're here, we're talking to people about all of this. When you look at these restaurants that go and hotels that go with, let's just say, payroll companies, and they get these generic, sort of questionnaire handbooks or whatever, and they say, okay, check that off the list or whatever. I mean, at least they're doing something, but that's really not good enough, is it?
You're correct.
Okay.
I've actually seen a lot of payroll companies misapply certain things. Down to one issue is they don't have the proper listing on the pay stub of the paid sick time that's been accrued, the paid sick time that's been used, and then the dollar amount.
Yeah.
Even I just noticed recently, and I'm not going to name the payroll company, but they did not have those on the check stubs, and that's required by Arizona law. And it's been required by Arizona law since 2017, I think.
And the client doesn't even know.
The client doesn't know because they're paying the payroll company to do things correctly.
And at the end of the day, the client ends up being liable if something happens.
Exactly.
Yeah, because those third parties are just going to wash their hands of it.
Yes, and I've actually had a client go back and say, hey, you did this incorrectly, and they said, well, oh well.
Yeah, not our problem.
Not our problem.
Yeah, no, oh goodness. Okay, let's also talk about, because I'm going to have a list of questions that I think you'll be able to answer pretty shortly, because we had gone over them, and I know they are of interest. And so a lot of your answer with some of these questions is going to be do the proper investigation. So what does that mean? What's the definition of a proper investigation somebody can do if something happens?
So the easy answer to your question is it depends.
Yeah.
I'll start with, it depends on how big or small the problem is, okay? Let's say it's just a small issue between two lower level employees. I think an internal investigation, meaning the company having HR or an upper level manager do the investigation, I think that that's okay. If it starts to get bigger or becomes too much for either HR or the company to handle, that's when you need to hire an external investigator or a lawyer who can serve as the external investigator.
Yeah. And do you see a lot of, when it's attributable to what I do for a living, do you see a lot of insurance work on this basis, or do you see not a lot of people buying this sort of coverage because they don't understand, first of all, they don't really understand the liability of it, and they don't want to pay the extra expense most of the time.
Sure. I feel about maybe 30% of my clients have EPLI.
Yeah.
Some of them, when I say EPLI, they give me a deer in the headlights look.
Employment practice liability insurance.
And that's what I say to them after the deer in the headlight look.
Right.
And so most of what I do doesn't involve that sort of coverage because it's the preventative,
Yeah.
right? But once it hits the claim area, it becomes really important because then the insurance company will pay for the defense. And in most cases, and I say most because they will not indemnify on wage claims, but in most cases they will pay out any sort of damages or settlement.
Yeah, and there's a lot of limitations even in those policies, but it's better to have it and at least have some of the coverage for FSLA and wage and hour and all that sort of stuff than not have it.
Correct. And I will add that I think it's important when you do have EPLI to select the choice of counsel provision,
Yes.
because you spend years trying to prevent claims, and during those years you're building a relationship with the attorney that you have, and then all of a sudden a claim gets filed and you are transferred to an attorney you've never spoken to before, and you're not comfortable speaking to them, and when you're kind of at one of your more vulnerable moments.
Right, and so choice of counsel is really a term that if you have an EPLI policy now and you haven't seen whether or not you have that provision in your policy, I would certainly look it up or ask your agent if you do or not. And as Jodi said, it's good to see that if that is in there, that you can have whoever you want to represent you, because when you have something like that hits you so hard, I mean, if you're getting blamed for not running your business correctly because of something that's kind of weird that you may or may not have done, you want a comfortable face or somebody there to talk to.
Right. Exactly.
Yeah. That's crazy. Do you have any advice or besides Google, on just like documented training or courses or in-house, training that people can do?
Sure. Training, you can hire a lawyer like me to conduct sexual harassment training,
Okay.
if that's the type of training that you want. There's a lot of great entities out there, SHRM being one of them, and I think it's the Society for Human Resources Management.
Okay.
So SHRM. That provides a lot of good employment law information. I don't want to say advice, but information to companies who are just trying to do the right thing. Yeah,
and probably, if not twice a year, maybe have somebody come in like yourself to come and speak to, I would say all of them, but sometimes do people just do it with like upper management or?
Yeah, I think once a year is enough for an everybody sort of training, but if you want to really hone in on your managers, you can up that up to a second time a year.
And is there any, like with liquor training, is there any sort of certification of sitting in this hour or 2 hour lecture that they can kind of put in their handbook showing that if something were to happen, like, hey, we do this as well?
That's another thing that's incredibly helpful. When I conduct the trainings, I have an attendance roster passed out to where everybody signs it.
Yeah.
And so then if there is a complaint, then that's another piece of evidence that I use to defend. I tell the government, look, they take this incredibly seriously. They have mandatory trainings this many times a year. Here's the evidence showing that these people are attending the trainings.
And what would you say to clients or people that have like smaller restaurants, maybe 30 people, employees or something like that, one location, and they're like, yeah, it's just another expense that we can't afford?
Right. Well, if you can't afford a lawyer to pay the 1 hour sexual harassment training, you cannot afford to pay the lawyer for the claim that is going to subsequently come.
I like that answer. It's good.
Thank you.
All right. Some specific questions here that I'd like to ask. So when an employee accuses another employee of sexual harassment, what do you do?
Yeah, again, it kind of depends on the levels of each employee. If it's coworkers, it's probably something that could be handled internally. If you've got a subordinate supervisor situation, and it also depends on how egregious the allegations are. Is there anything physical? Is it just he made one joke?
Is it a picture in the phone that shouldn't have been sent?
That too. Yeah. So it really just kind of depends on how bad the complaint is, who the complaint involves. You always investigate the complaint because some people have raised, and I've seen this in my career, where they kind of want to do a preemptive complaint. They're going to complain about sexual harassment because they're afraid X, Y, or Z is going to happen. Right. And so you do need to investigate. And then whether you bring in an outside investigator really is dependent upon how bad the allegations are and who the allegations involve.
Okay. You suspect an employee has a substance abuse problem. What's the best thing to do?
Well, hopefully you have a drug and alcohol policy in place. And so what you first are going to document any sort of signs or symptoms of impairment. Once you've done that, if you think the employee is impaired in the workplace right in that moment, then you have a drug testing policy, you're going to send them off for drug testing.
Okay.
You are not going to send them off in their own car because you think they're impaired. My preference would be to have an employee drive that impaired employee to get drug testing. If that's not possible, you can require that the employee, depending on how impaired you think they are, to take an Uber and get them there. But then the company would be responsible for paying the Uber. So
here, this question may be totally off base, but I was thinking about while you're saying it. Marijuana is legal.
It is.
So
well, it's decriminalized in Arizona. That's my lawyer answer.
So I guess it would be the same as if somebody was drinking on the job. They shouldn't be high on the job too, right?
Sure. And just because it has been decriminalized in Arizona, that's hard to say, does not mean that employers are required to allow them to be high on the job.
Yeah.
And so, no, there were no added protections, employment protections for employees when it was decriminalized.
Very interesting. And that kind of falls into a work comp issue, which is a whole nother, webcast. But, like if somebody's high and they cut their finger, like.
Yeah. And again, if you believe that they are impaired, then when there's a work comp issue, again, hopefully you have a policy, you send them off to get tested.
Yeah.
Because that's going to determine the work comp coverage for the employee. I had one other thought that has just escaped me on the injury. Hopefully I'll be able to come back to that.
Just blurb it out when you find it.
Right.
Okay. When you suspect an employee is stealing or have pretty good proof, like on camera.
Oh, I can't tell you how many times. I'm actually in the seven figures at this point in helping clients who have discovered employees who have embezzled, which is really unfortunate. So, again, the answer is it depends on what sort of evidence you have. But to start, you're going to want to remove the employee from the area in which they have been stealing. So, if it's, a lot of times it's people who have access to check writing or deposits or something like that.
Over time.
Correct. Yeah. And oftentimes it can go years before they get caught. Yeah. So you're going to want to, depending on the evidence, you're going to want to confront them with the evidence. And you can't force them to stay and of course, admit to anything. But what you can do is you can kind of encourage them to try to help you with the investigation And then again, depending on the situation, I have had employees sign promissory notes and pay it back. I have reported this to the authorities. In fact, one of my clients had a guy who spent 5 years in jail.
Wow.
Because of the theft that he engaged in. So again, it depends on the relationship you've had with the employee, the extent of the embezzlement, and the type of theft. It could be really small. Hopefully it's small. And so you take all of those factors into consideration when you're deciding what to do.
Yeah, and look, I mean, these are great generic questions, but like you said, everything is situational. You know, you could have an employee that's a great friend of yours as an owner, and maybe they fell on hard times, didn't tell you, and started taking stuff. And like you said, you had somebody, give a promissory note that they're going to pay it back, and maybe that owner is accepting that, as opposed to maybe an accountant or somebody they have in house that's been stealing for years.
Right.
And they're like, you're going to jail.
And I've successfully seen the situation where the promissory note was signed and it's been paid out. And sadly, sometimes the embezzlement's so high, it's almost like a small mortgage. And so they're paying it out over 10 years. But I've seen that work successfully.
Yeah, that's, wow, the world we live in. In other countries, they just chop your hand off. So let's say an employee, I know we've talked about this a little bit, an employee accuses management of discrimination because of race, sexual orientation, stuff like that. So we're living in I guess to really parlay on top of that, we're living in a world of like, wow, there's a lot of stuff going on. And a lot of people, I think, maybe might feel slighted or not slighted or, certain things, differences of opinions. Like when does it really become a factor of this sort of harassment?
Yeah, so I cite this on a regular basis, but Title VII was not meant to be a general civility code. It really takes a lot of egregious behavior to constitute harassment.
Okay.
There are two different types of harassment. There is quid pro quo harassment, which means this for that, meaning sleep with me and I will give you a promotion.
Okay.
Or there is hostile work environment harassment, and that typically that requires the situation to be severe and pervasive. One instance can be severe and pervasive depending on what happened, such as an allegation of assault.
Okay.
Or it could just be a repetitive series of comments and actions, but it takes a lot for it to hit the hostile work environment. Once you have a management complaint involved, I think that's really important to make sure that you're getting HR involved. If it's a CEO level or other C-suite executive, I think you need to get an external investigator out who really has no skin in the game because they need to be unbiased when they're conducting the investigation.
Yeah. Wow. Yeah, if you don't know, you don't know. I mean, I'm learning so much just sitting here listening to you, and we've known each other for a long time. It's kind of a weird question, but I mean, is there a good way to terminate an employee? Is it that whole, hey, Friday, here's your box, go out the door?
Yeah, it's never easy. And I've actually been hired to help terminate employees. And I'll tell you, even when you're getting paid to do it, it's never fun.
Yeah.
But again, my answer is always going to be, it depends on the situation. And I always prepare contingency plans for my clients who've come to me and said, we've got to terminate this employee. What do we do?
Yeah.
Well, depending on the situation, if it's just a performance-based issue, that's generally easier than if there's a misconduct-based issue. But the time of day doesn't really matter. Whether it's a Monday or a Friday doesn't really matter. I think it's just you approach the employee respectfully and give them let them have a little bit of dignity and just let them know that it's just not working out. In person is always better.
Yeah.
With the remote workforce growing and growing, I've seen some have to do it via Zoom. Or I've had some clients have to fly out of state just to terminate an employee who resides in another state to collect all of the company property and those sorts of things.
I was going to ask you about that. Are there issues with like collecting manager keys if it's a manager, or the different things like within the restaurant that they actually have on person? I mean, they're obligated to give that back upon termination.
Well, they are.
But
whether they do or not is another thing, at least without issue. So yeah, another thing that I help clients with is reminding them, look, termination is an incredibly stressful situation. So I usually have talking points that I help clients prepare so that way they know what to go through and they don't forget to ask for those keys back. They don't forget to ask for that credit card back.
Yeah.
There's also things that need to be taken into consideration from behind the scenes. If it's an office setting, maybe a corporate office of a restaurant, so they have their own corporate side of things. They need to be terminated from the email access and the access to the server and those sorts of things, so they can't hurt the company by downloading things or taking secret recipes or the secret sauce.
That makes sense. Do you have a specific termination outfit that you wear when you get hired to go do it?
This one.
No. I'm getting terminated, folks. Can you terminate without cause?
Absolutely. Under most circumstances. Okay. So Arizona is an at-will employment state, meaning you can fire an employee for any reason, so long as it's not an illegal reason. If the employee has an employment contract that says that they're not an at-will employee, then you need to determine, based on the parameters of the contract, how you can terminate the employee. You may still be able to terminate them without cause, but maybe you have to give them 30 days notice. Okay. Or if there is cause, sometimes you have to provide them with what's called the opportunity to cure or fix the situation before they could be terminated for cause.
And what's kind of the layman's term of at will? What does that mean?
Again, it means you could be fired either party can terminate the employment relationship for any reason. The employee could resign. The company can terminate the employee without any notice.
Okay.
Yes.
And is there a leg to stand on when it comes to non-competes, if there was one within the employment contract?
Non-competes are getting harder and harder to enforce, especially with the shift in the administration. And I always get this wrong. I think it's the FTC, the Fair Trade Commission, who is currently working on regulations to say that non-competes are not enforceable.
Yeah.
That is not a current regulation. It is, I believe it's in the proposed rulemaking setting. And I think once it becomes a rule, you're going to see a bunch of businesses file a lawsuit to have a restraining order entered into it, so it can't be enforced. So I think it's going to be a while before we see that change. Yeah. That being said, they are getting harder and harder to enforce. But non-competes are different than non-solicitations, okay? And while they're still disfavored, there are, if it's crafted narrowly enough, they can be enforceable in Arizona.
So in hospitality, though, in insurance, I see non-competes all the time. In hospitality, you don't really see Joe, the manager that's working at, this restaurant group, not being able to go work over at this other, they poach people all the time.
You can, if there's no agreement. Yeah. So yes, if you want your managers to not be able to solicit your employees when they go from one restaurant group to another, then you're going to have this manager sign a non-solicitation provision. Okay. You also have to keep in mind that there are vendors and other things that you learn as a manager, and you're learning the pricing that you have with your vendors. And those are types of things that you're going to want to protect with a confidentiality agreement.
1,000%. Yeah, that makes sense. I think we covered this, management course for first-time managers. I think you had mentioned
Yeah, I would suggest, mostly for HR, that there's the SHRM that you can, there's a lot of different courses that they offer over the year.
Okay.
Yeah.
We'll put that in notes too, SHRM. And then what is the Arizona law for maternity leave?
There is no Arizona law for maternity leave. So essentially what that means is if you have at least 50 employees, and I'm not going to get into all the specifics, but if you have at least 50 employees, then your employees are protected by the Family Medical Leave Act, which provides for 12 weeks of unpaid leave under certain circumstances. And so that would be the maternity leave that you have to grant the employee.
Okay, that makes sense. And then I guess last but not least, what is the Arizona law for sick leave, time off, vacation, hourly, all that good stuff?
Sure. So again, Arizona doesn't have a paid vacation law, but it does have a paid sick time law. And that says that an employer has to allow an employee to accrue 1 hour of paid sick time for every 30 hours worked up to the cap. The cap is determined by the size of the company. If you have less than 15 employees, then the cap is 24 hours. If you have 15 or more employees, then the cap is 40 hours. And then, of course, there are so many different hosts of issues that or questions that arise. I'm trying to think of one of them.
Like what constitutes an employee?
Well, anybody that's going to be a W-2, right? If you're a W-2, you're an employee. Well, you could be misclassified as a 1099. That's just a whole other issue that we could.
Can of worms. Yeah, that's why you need to hire her to get because.
But with again, you have to be able to. You have to tell your employees when they can take it off, how they can take it off. How do they go about telling their managers that they need to take it off? And so there's all sorts. This is why a paid sick time policy is probably one of the most important policies to have, even if you have one employee, because the moment you have one employee, you have to follow this law.
Yeah, and if you're an independent contractor, you can't determine their day at all. You can't tell them what to do as an independent contractor.
No, and again, that's another thing that's shifting with the administration right now. Trump, I don't even know how to get into all of this because it would take a long time, but Trump proposed some regulations. Those regulations were supposed to take effect in March of 2021, I believe. The Biden administration did some things. It went into court, all sorts of issues, but right now we've got the Biden administration trying to work to almost effectively get rid of the gig economy right now.
So, okay, well.
Not to be a downer.
Yeah. Any other tips to anybody before we convene here?
No, I think just kind of keep your eyes open right now because there's a lot of things changing. Here's one recent change that maybe your clients don't know. And I've told all my clients whether they listen to me or not when I send out my employment law advisories or one thing, but agencies can reverse themselves. So recently, I think it was February, the National Labor Relations Board, which even if you're not unionized, still governs companies because they protect employees in engaging in collective concerted activity. Excuse me. And so they've said, look, you can no longer put non-disparagement provisions in your severance agreements. And you can, with some exceptions, can't really have those confidentiality provisions in there either.
Yeah.
So all sorts of things are changing all the time.
And that's why it's so important to find a specialist in, at the end of the day, you're a lawyer, I'm an insurance person, but what you do is so specific to all you have to have somebody that is on top of all these laws and all these things, or else you're going to get the wrong advice.
Yeah, and it's better to go back to your lawyer. So keep in mind, I've got clients, I've given drafts of severance agreements for years and years and years.
Yeah.
And if they don't come to me every time there's an issue, they could then send out one of my old drafts, but now the provisions that were in there that were lawful 6 months ago, they're no longer lawful.
And do you still have your own specific newsletter and all that you put out, or?
I write for the Arizona Employment Law Letter.
Okay.
And then I don't publish, but I post every single article that I write on Tiffany and Bosco's website under my profile.
All right, we'll have to get a link to all that stuff because, again, this is all very helpful stuff. And this is a lot to even just intake, so maybe you might want to watch this like 5 or 6 times because I'm probably going to have to. So, all right, Jodi Bohr. I can't believe I did that. I appreciate you coming and hanging out with me today.
Thanks for having me.
And I look forward to our next lunch at True Foods?
True Foods or Zenburger.
Or Zenburger.
Those are our
go-tos. one of the two. So thank you everybody for watching, and check Jodi's information out down in the description and all that. And until next time, let me know what the next sort of video that you'd like to see. I think I'm going to go with accounting and restaurant accounting next. So thanks.